Hello, everyone. This is Tom Fox back for our closing episode on our series on failure to prevent fraud. We're going to really put a capstone on it today, and you're in for a huge treat. I'm going to let each of our panelists, our guests, introduce themselves, and I'll start with you, Zoe.
Thank you, Tom, and thank you, everybody. I'm Zoe Osborne. I'm a London-based investigations and white-collar partner at Steptoe. I specialise in investigations and enforcement, whether it's fraud, corruption, bribery, etc. And I think because I know where the bodies are buried, I help a lot in relation to clients managing risk.
Judy?
Hi, I'm Judy Krieg. I'm a London-based US and UK lawyer, and I've looked at these issues from different perspectives. I was previously a chief compliance officer of a company that had a little bit of a bribery problem in the UK called Rolls-Royce. I'm the former head of fraud, bribery, and corruption at the UK Serious Fraud Office, but I also have a software engineering degree. So when I approach these issues, it's also from US, UK, as well as legal and tech perspective.
And Matt.
Hi, I'm Matt Galvin. Like Zoe, I'm a partner with Steptoe in the White Collar Group based in DC. Unlike Zoe, I try to keep the bodies from needing to be buried. I help companies both with investigations, but also designing compliance programs. I was recently at the Department of Justice, where I would oversee compliance evaluations and also built out data analytics to identify and find white-collar crime. It's great to be back in the show, Tom.
We have 3 of 4 of us who have gone through both an FCPA enforcement action and the resulting, at least one of us, a monitor. So that's a pretty unique group. So Zoe, I'm going to ask you to maybe kick us off.
Of course, thank you, Tom. I've got the easy part, I think, of today. I'm just going to talk 2 or 3 minutes about what the failure to prevent fraud offence is. It's the third in the line of failure to prevent fraud offences in the UK. It came into effect on the 1st of September, so it's quite new. It was introduced by what we call the Economic Crime and Transparency Act. And as I say, it's the third in the line of these strict liability corporate offences where there's an available defence of adequate procedures. And I think that's something that Matt will pick up on, and it's particularly important in the technology space. I've just said it's a UK offence, but I'd like to sort of qualify that. It has an extremely broad reach. The jurisdictional requirements for it require only a very limited nexus to the UK. It's, I think, more akin to the Foreign Corrupt Practices Act, where if you can show any nexus to the UK, a potential benefit to the UK, a potential harm to the UK, you're likely to be caught by it. In a nutshell, the offence covers large organisations, over 36 million in annual turnover, 18 million in balance sheet assets, or over 250 employees. And a large organisation is going to be guilty of an offence where an associated person, which is a term I'm sure we're all aware of because of working on the Bribery Act, commits a relevant fraud offence intending to benefit that large organisation. So 3 elements very quickly. A person associated with the organisation, again, a term we're all used to from the Bribery Act, but it's incredibly broadly defined. An employee, agent, subsidiary, anything like that. Element 2 is going to be where a relevant fraud offence has been committed. The list of fraud offences which are captured by the Act are listed in the legislation, but it's going to include things like fraud by false representation, obtaining services dishonestly, false accounting, false statements. So think about offences like cooking the books, like making misleading statements in public procurement exercises, or indeed, I think the topic of the month, at least here, is making false statements in relation to trying to greenwash things, ESG type issues. It also includes aiding and abetting and counselling, that sort of thing. The third element to the offence is what we call the benefit requirement, which very simply is that the offence is only going to bite where the associated person intends to benefit the organisation. So if the company is going to suffer as a result of the act, that's not caught. It's only if the company benefits. Penalties are going to be very large fines. As I said, so broad, so very depressing. But just like the other 2 failure to prevent offences, there is going to be a defence where the company has adequate procedures in place to stop it happening. It's going to be a civil standard, so on the balance of probabilities that you had reasonable fraud prevention in place. these sorts of things that one would look at in terms of whether you've got adequate procedures in place or whether you've performed a risk assessment, whether there's proportionate policies in place, whether due diligence has been undertaken, whether you've communicated those policies, i.e. training to your employees, monitoring and review, and the old favourite of tone from the top are the management actually embedding these sorts of procedures within the organisation. That's a whistle-stop tour, Tom. That's the offence.
Thank you, Zoe. Judy?
Thanks. So as Zoe says, this is all quite new. And of course, the magic words are reasonable procedures. Have you got those reasonable procedures in place? And that's what Matt's going to talk about in terms of the use of AI. So where I'm going to come in is just give you a few minutes on, for this new offense, who are the likely enforcers and how are they going to view your adoption of AI or how you're using AI for your reasonable procedures. Now, in the UK, I know many of you may be familiar with the Serious Fraud Office, but there's actually 3 potential criminal enforcers of this statute. And I'm going to briefly give you a flavor for all 3. First one is the Serious Fraud Office. Second one is the Crown Prosecution Service. And the third one is the Financial Conduct Authority. So let's start with the SFO. The key is in the name, F, fraud. You would think that this is going to be where you're likely going to end up if you end up with a problem here, but that's not necessarily the case. The SFO is a specialist investigator and prosecutor. And in the UK, that's relatively unique that the investigation and prosecution is in the same body. The SFO is a relatively small niche enforcer, and it has a very limited caseload. It picks which cases it wants. Roughly at any point in time, you can expect about 30 fraud or bribery cases to be within the 4 walls of the SFO. The SFO does have accountants on staff, but those accountants tend to be forensic accountants. They're not the type of accountants that you would think of as auditors or as accountants that would be within a company under Sarbanes-Oxley or what have you, helping to develop those fraud procedures, anti-fraud procedures. So it's not likely that somebody from within the SFO is going to be given that expert view. The SFO does not currently, and as far as I'm aware, has never advertised a specialist compliance role. And I don't know if Matt's going to talk about that, but as the DOJ did have specialist compliance roles, at the SFO, they don't. So that in-house expertise of how to assess the procedures doesn't exist within the SFO. The SFO does have a history of entering into deferred prosecution agreements. And one of the keys to failure to prevent fraud is that you've got the corporate offense of the failure to prevent fraud, but you also have to prove an underlying fraud offense by an associated person. So that balance between how do you treat the corporate and the individuals, the SFO has a relatively good, relatively strong, long track record of about a dozen, not quite DPAs. Less impressive track record when it comes to enforcing against the individuals and proving the cases against the individuals. So, for example, Rolls-Royce, Airbus, the companies agreed the DPA, but the SFO never put those individuals to proof. They never actually charged individuals. And so when you think about how the SFO might treat a case like that comes within their 4 walls, the last thing I want to point out is that the SFO has notoriously outdated technology. And nothing I'm telling you is private, it's all public record. Right now, the Serious Fraud Office in 2025, as we're recording this, is running a 2023 version of its evidence review platform. They're talking about technology-assisted review as being cutting edge. So you can get some flavor of if you're going to be adopting some of the AI things that Matt's talking about, as of today's standards, what might be reasonable, likely to be pretty far ahead where the SFO itself is. That's the SFO. Second, I want to talk a little bit about the Crown Prosecution Service. And this is where you typically see prosecutions happen in the UK. They are the prosecutor of record in the UK. So for a number of different investigative agencies, the police forces, the taxing authority, it's the Crown Prosecution Service who's been doing the prosecuting. They don't investigate, they only prosecute. The key is in that name, P stands for prosecution. They do have specialist units that do deal with the complex and corporate cases. The most recent bribery deferred prosecution agreement actually came from the CPS, and that's the Entain DPA. It did not come through the SFO. So the CPS does and can handle complex fraud cases like the ones we're talking about here. They also do not have, as far as I'm aware, any dedicated compliance roles. They do not have dedicated accountants, particularly ones that you would expect to be assessing the reasonableness of your anti-fraud controls. And they also tend to be, shall I say, a bit more outdated in their tech. For example, they're now talking about rolling out Copilot in Microsoft to help them write their emails and some of their correspondence. So again, that's the level of technology that you're talking about for the proper civil service prosecutors, and that's the CPS and the Serious Fraud Office. So lastly, I just want to briefly throw into the mix the Financial Conduct Authority. Now, the Financial Conduct Authority is a very unique beast because it is a prosecutor and an investigator and a regulator, perhaps first and foremost. It covers all the financial services industry in the UK, and that covers a huge swath. It covers more than just banks. It covers all the insurance industry and a lot more than what you would think of in the US as financial services. It also has jurisdiction over listed companies that are listed on the London Stock Exchange or on the AIM Exchange. And if there's misrepresentations in either the offerings or in the accounts of those companies, these are the big companies that we would expect to be caught within the Failure to Prevent Fraud offense. The FCA actually has enforcement authorities. They can and do charge fraud in those cases and fraud offenses that do get caught under the Failure to Prevent Fraud. Now, again, the FCA, because it is a much bigger organization, because of that huge regulatory jurisdiction it's got, they do have accountants, but again, they tend to be forensic. They don't have dedicated compliance roles, but unlike the SFO or the CPS, the FCA has a very significant track record of assessing companies' controls, and then particularly in the financial crime space, because that's part of what their regulator role is. So if you were to find yourself dealing with the FCA on one of these matters, you should expect that they are more attuned to how to assess somebody's controls. They will bring in outside experts. They do it quite frequently. And there's, in fact, a part of the statute that talks about how they bring in experts to do with these sorts of assessments. But the FCA also has much better tech expertise, and they're much more embracing of tech. Partly that's in their internal systems, and the FCA has a lot more data that they deal with because they have all that data from their role as regulator. So you see that the FCA has a lot more systems in place to handle the big data and use the sorts of systems and tools that Matt's going to talk about. They also have remit over regulating crypto. And they also have had, for several years now, a sandbox program for tech startups, for fintech startups. All of this should give you the impression that the FCA is definitely going to be looking for you to be embracing some sort of tech and AI. I dare say they would expect that to be reasonable because they do that themselves. Now, on the other hand, though, the FCA has never entered into a DPA. And technically speaking, they're not a designated prosecutor under the law that allowed DPAs to happen in the UK. They could be designated. But when you're thinking about that sort of holistic picture of if you were to have a problem, how would somebody be looking at your use of or not the AI tools that Matt's going to talk about? There's definitely different factors to think about with the FCA. Unfortunately, you don't get to pick or choose if you do have a problem, who it is that's going to be looking at you. But if you are, or if you have UK operations that are listed in either the London exchanges, or if you're within the FCA's remit, it's a pretty safe bet that at least in the first instance, the FCA would be the one knocking on your door. So that, again, is a whistle-stop tour of as you're thinking about what should you be putting into place and why you should be putting this into place, that's how it might be viewed down the road. Matt, over to you.
Yeah, what's difficult to forecast is at the time when, if you're ever in a circumstance where you need to defend your program, there's going to be a bias to the level of technology at the time of presentation. Often you kind of enter an investigation, and by the time they got to me and my role of compliance review, it was like 4 years later. And when you think about that and the pace of technological change now, some of it is what bets should you be placing on preventing fraud now that will age well in 4 years? Because the pace is kind of radically fast. In March, Anthropic came out with a new code that they demonstrated could basically take a programmer and make them 4x more effective, which has such like a flywheel, almost equivalent, if not greater, impact of Moore's Law on the pace of AI change. And when I was at Justice, I met with the FCA and SFO and regulators from around the world. We talked and shared some technologies. And it's interesting to see, I know where they are now, I have a good sense, but where they will be as this evolves is anyone's guess. And I don't think it's going to be evenly distributed. Where one of the entities might be particularly good at kind of securities analytics and looking at that sort of fraud, they might be less good at some of the things Zoe was talking about, like the book cooking or the greenwashing or the general procurement fraud, any of which have, even in current state of technology, pretty cool compliance solutions. Now, she also used the word proportionate, which is an interesting word, right? A lot of times in the securities context, proportionate is to the size of the business, whether it's material. In justice, I lobby to put in the ECCP this concept of proportionality to what technology are you using something proportionate to the technology that the commercial parts of the business are using. So if you're using advanced AI models to sell toothpaste, are you also using somewhat close to that on toothpaste fraud? Or did your kids brush their teeth? Which would be amazing if AI could tell me if my kids brush their teeth. But let's take those three specific examples. What is the state of technology now with either book cooking or greenwashing or procurement fraud? Book cooking or cooking the books is interesting because there's now really good AI technology that will take huge, vast amounts of bank statement data that traditionally with a regular kind of scanning technology would take 7-8 months to put together. And you can very quickly now, in about a week or less than a week, put vast amounts of bank statement data, link them all together, and then overlay them against an ERP system. So you can do a very quick reconciliation between bank accounts and ERP systems. That process, which is very expensive and labor intensive, is now really neither. And whether you use that in an investigative context, or that's something that like any regulator or prosecutor, they can buy that ability. So it's not something they need kind of native ability to do. Whether it then evolves into kind of a more of a compliance standard remains to be seen. These things are interesting in terms of at what point does the technological tipping point go so it becomes kind of a duty of care to do it. But I think this is an available technology now. Greenwashing is another interesting one. We had a number of projects where you could take and subject to an LLM every securities filing, everything on Edgar, or everything filed with the UK regulators. And then you could ask it, what did they say about greenwashing and how does that compare to on a standard deviation of other kind of peer companies? And you can quickly triangulate that. I've seen a lot of very interesting work on that in terms of earnings reports, where you take either SEC or you can kind of digitalize all of the earnings calls. And you can measure that for like evasion or directness or candor. And you can come up with scores that are fairly well defined in the like advertising marketing context, import them over to a crime fighting investigative context, and really see risk scores pop out in terms of here are the claims that someone makes in terms of their kind of greenness. And then here's the interview, and here they're scoring high for evasion despite having very significant claims. And you can triangulate very quickly risk around greenwashing. And that would be both an investigative technique, or if you're thinking of a prophylactic way to kind of manage risk. And again, what's a kind of dynamically getting cheaper market for that kind of Moore's law, programming law direction, this stuff's becoming more direct. And procurement fraud. Here are areas in the US in aspects of the fraud division, we're very advanced in terms of advanced procurement analytics. And for 10 years, right, since BrewRite was first developed, where we were doing advanced analytics in AB InBev for procurement fraud within a company. And so while I was actually talking to a CCO yesterday who in his prior gig tried to do that and was going in procurement analytics and quickly got frustrated because, I mean, if you're going to randomly sample, as I looked at AB InBev, you get to 1 in 3,500. And even if you apply a set of rules, which is where a lot of people start out with in terms of AI procurement analysis, it's still 1 in 600-700 things you're looking at where you actually find something probative. You need to use kind of much more sophisticated techniques. And there's not yet like a general purpose AI, the way you can subject like securities filings and unstructured language to that. But there are tools in the market that can get you a lot better than 1 in 3,500 or 1 in 700. and being discerning with how you do that, both either to investigate procurement fraud or identify fraud, risk, or control, or understanding how the government, kind of the state of the art of the government algorithms, because different kind of government agencies, even outside the crime units, like the fraud units or audit units within governments, can have fairly sophisticated technology that they can look and triangulate risk to both help inform kind of regulatory action or prosecution. So all these spaces are moving really quickly. If you're kind of deciding where to place your bets, I think some of it is what is your risk profile of a company? What are the capabilities you have to manage that risk? What is the kind of regulatory kind of risk? Where do you think they'll be able to get to? And where do you see yourself in 4 or 5 years? And then the nice thing about doing anti-fraud analytics is you save your company money. Often, if you're good at measuring success, it's not just a regulatory endeavor. It's an endeavor which is a rare thing, as I think the former CCOs in the call know, where you can win friends within a company as opposed to just enforcing the rules. And so I think I'm very bullish on the kind of state of technology and think it's going to play a critical role as UK law evolves in terms of how risk managers and CCOs across the pond are thinking about managing their risk.
So I've got lots of questions. And Matt, actually, I'm going to start with you with what you started with. As I wrote down bias towards the most recent tech, I wrote recency bias there because it was my observation, certainly in the past decade of FCPA enforcement, was you were judged or graded at the time you were evaluated by the Department of Justice as to the state of your program at that point, not when the incident may have occurred. And you, I thought, made that same point around technology. Could you expand on that maybe a little bit?
Yeah, I think if I remember correctly, the sentencing guidelines, there's a ratio of where you are now versus where you are at the time of conduct. And there are some stakeholders that would argue that it should be where are you in terms of your compliance maturity or your technological evolution into relation at the time when the underlying misconduct occurred. But even if that were the case, as a pragmatic matter, given the expanse of time and given just the way the presentation works, and given the fact that best case, you have an 8-hour period to review like what's potentially 300,000 people globally compliance program. And in the context of that presentation, where like the data analytics or technology is only going to be a component part of the things that you're looking at, it's going to be your advocates are going to show the best version of that, and that's going to be the latest version of that. And it's going to be at some point difficult to discern where are they now versus where are they before. And reasonable people can differ in terms of what's the right incentive structure. I think there's a good argument that the right incentive structure would be the time of the conduct, because everyone knows where once there's an issue, companies suddenly you're like a very powerful CCO. You get all sorts of budget, you get all sorts of issues to put things out. But really, the measure of a company is often, are you kind of managing these risks before as they go? Again, that's a very hard argument to make to management because they're not looking at a set of compliance risks. They're looking at a global spectrum of tariffs or regulatory sanctions, all sorts of risks beyond their kind of macroeconomic business, people, all sorts of risks they're thinking of. So it is hard to get that level of focus on something like a bribery or even a fraud in the kind of portfolio of risk until there's a catalyst event or you're in an industry where you see that happening around you. But I think in an ideal, my client compliance fantasy world, everyone would be investing at all times only in compliance. That's not really, I suspect, how the world works, Tom.
Judy or Zoe, I'm not quite sure which one of you all would take this next one, but could you explain for an American audience the UK DPA process?
It's not a million miles away from the U.S. one. So basically, the DPAs came into law in the UK. The statute was passed in 2013, and the code of practice was adopted in 2014. And the UK, I think Antane was the 12th DPA for the whole country. But some of the big differences, though, so basically, you have to be invited by the prosecutor to enter into negotiations. And then once you enter into the negotiations, if you reach an agreement, there is a different process in the UK where that is then heard before a judge in private. The judge does have more oversight. And then if the judge is inclined to then approve this, there is then a second public hearing. I think one of the key differences, though, from my perspective about the DPA process in the UK is that the prosecutor in the UK can enter into a DPA even if they don't have sufficient evidence yet to prosecute the case. If there is a reasonable likelihood that continued investigation would get you there. And so what you see in the UK, unlike the US, is that DPAs get entered into with companies when the prosecutor doesn't have their ducks in a row for those individual charges. And that's a real marked difference than the US. For example, Rolls-Royce DPA. The day that the Rolls-Royce DPA was filed with the court, the individual charges against the key individuals were also filed under seal. And those two lined up. In the UK, it doesn't work that way. And this is why we see this sort of asymmetry between the corporate outcome and the individual outcome, which is going to be a very important factor as and when, when the UK decides to actually prosecute this failure to prevent fraud offense, because part and parcel of proving that offense against the corporate is you must prove an underlying criminal offense by an individual to a criminal standard. So the prosecutor won't be able to, if I can use the words, get away with what they've done so far in the UK, which is that you get DPAs that get entered into because the companies are more than happy to get rid of the investigation and to quit the pain and to be done with it. And in the UK, we've got companies that have agreed DPAs. We also have a company, maybe two, that have agreed guilty pleas. But that doesn't mean that the prosecutor was ready or actually did file charges against individuals. And so what we are now seeing in the UK is a little bit of that hopefully catching up, potentially catching up. Petrofac individuals have been charged and the Glencore individuals have been charged. But particularly on fraud, if you look at the G4S case and the Serco case, both of which were DPA cases, the company agreed the DPA set of facts all through the, again, sort of similar process to the US. But then when it came time for the SFO to prosecute the individuals to that criminal standard, for different reasons, related reasons, those cases fell apart. So the DPA process is not that different, but the timing and that quantum of evidence to sort of tie together the corporate and the individual actually is quite different in the UK.
Zoe, I'd like to maybe ask you to expand on some of your thoughts around extraterritorial jurisdiction, but I want to preface it with an example from the Bribery Act and its difference with the U.S. Foreign Corrupt Practices Act in the area of facilitation payments. Certain types of payments are exempted out of the FCPA. That does not appear in the Bribery Act. And so for energy companies headquartered in Texas, they would always have a UK subsidiary, and they face the challenge, do we ban facilitation payments or do we exempt out, with all the administrative hassles that means, all of the employees of our UK subsidiary or any company from the United Kingdom we might have a master services agreement with? And it really drove home the point to energy companies, you needed to have one policy for worldwide. And so I wanted to use that to maybe introduce to our audience, what are some of the jurisdictional issues for a U.S. company with a UK subsidiary or a UK company with a U.S. subsidiary?
Yeah, and you're absolutely right about the Bribery Act. And certainly my experience of clients is that they've gone for a global policy which bans all of facilitation payments just because of this Bribery Act extraterritorial scope. I guess the issue with the Fraud Act is that because any nexus to the UK is going to be caught. Just to give an example, a large UK organisation operating mainly outside of the UK, not involving a UK employee, not a UK citizen, the only nexus to the UK being perhaps an indirect victim in the UK is going to be caught by the offence. So it's incredibly broad and could catch anybody.
So, guys, we are unfortunately near the end of our time for this episode. But before we leave, I'm going to ask each of you to give perhaps some closing remarks on what do you think the most important things for a U.S. audience to be aware of around the failure to prevent fraud. And I recognize, because most of our audience is in the United States, and I'm still not sure they fully understand the implications of the failure to prevent fraud offense. Zoe, can I start with you?
Yeah, I'm going to go back, unfortunately, to the jurisdictional reach of it. The offence could be triggered by misconduct by a subsidiary. So the fact that you are not UK headquartered, whatever, if there's a limited nexus to the UK, you could be caught.
Judy?
I'm going to come back to something that Matt sort of alluded to. When you're thinking about using AI for your fraud controls and how to deal with this, document your thinking. There's a saying in the UK that if it's not written down, it never happened. And as you're going through that balance of should we or shouldn't we, to Matt's point, you want to make sure that you're assessed on the state of the art now, your decision making now, and showing that it was reasonable now. So as you're going through this process, make sure you're documenting your thinking.
Matt?
I think as you move to a more tech-forward risk management program, what happens, there's a convergence of second-line functions, where you might have a control group, you have an audit group, third line, you have a compliance group, you have another legal group, and they all tend to want the same kind of data sources. They want to pipe into different, under the same commercial data systems. And whether you're looking at it for fraud or for your ABAC concerns or for export control concerns, the way the technology is evolving is you'll just have kind of different layers of AI that's parsing through the same data sets. So if you're thinking of like a holistic risk management strategy and you want to comply with US and UK laws, you can solve it by processing everything to death, or you can solve it with kind of a more advanced kind of data forward strategy, where then you're kind of realizing kind of strengths in numbers, and you can kind of train and tailor models, tune models by like a collective action and build a risk management asset within a company. To me, that is a better strategic vision for global compliance than for having a lot of process with a lot of different UK sites and overfitting to where you are. I think that's, to me, attractive and probably net in a very short time order, a much more cost-effective way to manage these risks.
Ladies and gentlemen, I wanted to thank you all again. It's been great to have you on, and I think this has been a great way to end this season of data-driven compliance around the failure to prevent fraud offense. Thank you, Ball.
Thank you.
Thanks, Tom.